We have to break down in some more geeky detail Judge Stephen McGlynn's decision involving the Illinois quote-unquote assault weapon ban to make you the smartest person in the room. As you know, last week, Judge McGlynn issued over 160 pages of opinions after a trial, finding that AR-15 semi-automatic rifles, magazines that hold more than 10 rounds, registration of firearms, were all unconstitutional. But I want to break down some of his rationales so you understand what he was thinking and why he was thinking it. And I also want to point out areas where the United States Court of Appeals for the Seventh Circuit that set forth this body of law is clearly wrong when you compare it to the precedent of the United States Supreme Court. Nevertheless, even under the terrible rationale and ruling of the Seventh Circuit, the Second Amendment community won big time in front of Judge McGlynn. Let's break it all down when we come back. Hey folks, I'm Mark Smith, host of the 4 Box of Dine, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of a new law review article, nice piece of scholarship in the Georgetown Journal of Law and Public Policy. The title of the article, Dangerous but Not Unusual, Mistakes Commonly Made by Courts in the Post-Bruin Litigation World, by yours truly, Mark Smith. Check it out down below. Put in a link to it down below. It's totally free. Just click on it or check it out, and you'll be the smartest person in the room. I cover Rahimi and all sorts of things about how to apply the Second Amendment. It's must reading if you're litigating these cases, if you're a scholar, if you're a historian, if you're a law clerk, and so on. It's must reading if you're involved with the Second Amendment. And these legal issues, you cannot ignore my article. It's mission critical. I'm sure people will be relying upon it and talking about it far into the future, involving our ongoing fight to keep and bear arms. All right, folks, with that said, let's turn our attention to the state of Illinois. As you know, Illinois enacted a terrible anti-gun law that banned a bunch of guns, AR-15s, AK-47s, magazine holding more than 10 rounds, had registration lists, and so on and so on. This issue went to the United States Court of Appeals for the Seventh Circuit based in Chicago, Illinois, and in a terrible 2-1 decision with 2 judges, both of whom are bitter that they didn't make the Supreme Court. One, Frank Easterbrook, the Republican, one, Diane Wood, the Democrat, and a Trump appointee, Michael Brennan. The Trump appointee, Michael Brennan, wrote a powerful dissent that basically got the law of the Second Amendment correct. And that was good, but the 2 judges of the majority, Judge Easterbrook and Judge Wood, screwed up the Second Amendment entirely. Nevertheless, after doing so and denying the preliminary injunction in favor of the Second Amendment, they sent this case back down, saying, well, our mind is still open. Maybe something will change. And they sent this case back down to Judge Stephen McGlynn, the district court judge in the Southern District of Illinois, to have a trial on this case as to whether or not the state of Illinois could justify under the Second Amendment, their various gun control laws. And it turns out, based on Judge McGlynn's 160-plus odd page ruling, that the state of Illinois failed utterly to prove what they needed to prove to justify this modern-day gun control law, with a few narrow exceptions, which we won't get into for this particular video. Now, with that said, I want to walk you through what Judge McGlynn said he had to do based on the precedent set by the Seventh Circuit in the Bevis case. Now, Judge McGlynn clearly disagrees with the law set forth by the Seventh Circuit. Nevertheless, because he's a district court judge and a superior court judge, superior court to him is the U.S. Court of Appeals for the Seventh Circuit. He is bound to follow the law of the Seventh Circuit. When they tell him what to do, he has to do it. It's the nature of the hierarchy of courts. So that is what he did. Nevertheless, even though he followed the law of the Seventh Circuit, which is not accurate, but he followed anyway, he still found that the Second Amendment prevailed and these gun control laws fell by the wayside. Now, let's just see what Judge McGlynn did. He basically said there was 3 things he had to do at the textual level. At the textual level, as you know, the text of the Second Amendment reads, "The right of the people to keep and bear arms shall not be infringed." Now, textually, the Supreme Court has defined all those terms, and you simply have to apply those terms. Obviously, the Illinois gun law would be implicated by that, and the burden would shift to the government to show all sorts of things. But the Seventh Circuit Court of Appeals, with 2 bitter judges that aren't on the Supreme Court, Judge Wood and Judge Easterbrook, screwed this up and basically elevated a whole bunch of things that the burden should be on the government and elevated it to the textual level, i.e. text first and then history second. And why did they do that? You know why they did that. The anti-gun movement in America wants to elevate every single question of law involving the Second Amendment to the textual level. Why is that? Because the burden of proof shifts to the government to justify their modern-day gun control laws if you're dealing at the second level, the historical level. But at the textual level, to show that a modern-day gun control law is implicated by the text of the Second Amendment, that is really a question really mostly for the plaintiff to plead properly. Nevertheless, the Seventh Circuit screwed this up entirely and said there was three things that the Second Amendment plaintiffs had the burden to prove. First is that the weapons or the arms involved in this particular law, in this particular case, that these arms in question are items that an ordinary person would keep in the home for the purposes of self-defense. That's the first thing. It should not be part of the text, but that's what the Seventh Circuit said, and that's what Judge McGlynn had to address. The second thing that the Seventh Circuit said that Judge McGlynn had to figure out, again, another error by the Seventh Circuit. Nevertheless, they are the boss for the moment in front of Judge McGlynn or above Judge McGlynn. And the second thing that the Seventh Circuit told Judge McGlynn to figure out is whether or not the weaponry or the arms in question are exclusively or not exclusively or predominantly or not predominantly useful in military service. The third thing that the Seventh Circuit told Judge McGlynn to figure out, as a matter of fact, is whether or not the arms or the weapons in question, in this case, against semi-automatic rifles and magazines that hold more than 10 rounds, whether or not they are possessed for lawful purposes or unlawful purposes. Are they predominantly used by criminals? And on a related note, of course, the Seventh Circuit said it's possible that an arm could have what's known as dual purposes or dual uses, i.e. it could be used both effectively for military purposes and effectively for civilian purposes. Now, again, the United States Supreme Court has made clear on multiple occasions that this supposed distinction between military firearms and civilian firearms does not exist. This is a distinction that does not exist in the law. Repeat after me. The distinction between military arms and civilian arms does not exist in Supreme Court precedent. This is BS, a myth, fakery, fake news. Nevertheless, the two anti-gun judges in the Seventh Circuit, injected this into this decision out of whole cloth. It's not there in Supreme Court precedent, but they did say that Judge McGlynn has to figure out whether or not these weapons are predominantly useful for military purposes or for civilian purposes, or if they're useful in both, then they're perfectly fine and constitutionally protected. Now, let's go on and see what Judge McGlynn does. Now, again, as a reminder, these questions are undeniably not supposed to be answered or even asked at the textual level of the Second Amendment. At the textual level, you just have to ask yourself, is the arm in question something that can be used offensively or defensively? And if the answer is yes, it's an arm. And it's presumptively protected. If it's barrel, meaning you can pick it up and carry it. That's it. If you can carry an arm, textually, the Second Amendment is satisfied, and the burden shifts to the government. But again, the anti-gunners and the anti-gun judges in America want all these fights to occur at the textual level because they don't want the burden to shift to the government to either prove these things or disprove these things, because the government, as a practical matter, is not capable of doing so because the history is not on their side, nor are the facts. So one of the games that the anti-gunners have played, which we talked about, is to elevate all these questions to the text first point of the question, or the text first part of the methodology, to avoid shifting the burden to the government, because the government simply cannot satisfy all these burdens. So with that said, we're going to carry on what Judge McGlynn did, and a reminder, Judge McGlynn is doing what he was told to do by the Seventh Circuit, which the U.S. Supreme Court, in my view, would absolutely not view this as correct application of the precedent or the text of the Second Amendment. Nevertheless, Judge McGlynn has to do what he's told by the Seventh Circuit, and that's what he did. The good news is he found in our favor in virtually all instances. So let's go to the first question he had to ask, directed to him by the U.S. Court of Appeals for the Seventh Circuit. The first question is the challenge weapon, these AR-15s, these semi-automatic rifles and magazines that hold more than 10 rounds, are these weapons items that an ordinary person, such as you and me, right, the two of us, we as a group, community, would we keep these at home for self-defense? And the court says, absolutely, these are clearly the types of weapons that would be kept at home for self-defense. The court, Judge McGlynn, points out that millions and millions of people own AR-15s, and even the state's experts that testified, the state's own expert testified and admitted that there's millions of these out there, and they're commonly owned, these modern sporting rifles, which are, again, I tell you, use semi-automatic rifles, but if you can call them a modern sporting rifle, but the more precise thing is to call them semi-automatic rifles, because that's what Justice Brett Kavanaugh calls them, and he's really the critical vote on this question ultimately. And he goes on to say not only are these semi-automatic weapons in common use, they're simply not dangerous and unusual. Now, this is quite interesting. I want to talk about this real quickly. You don't have to belabor this point, but you should just know about it. He tries to talk about what is dangerous and unusual. Now, again, if in theory you can ban something that is a dangerous and unusual weapon, once you find that it is in common use, it cannot be dangerous and unusual, obviously. Because if it's in common use, it cannot be unusual. And if it's in common use and it cannot be unusual, it by definition cannot be dangerous and unusual. Just simple logic, no brainer, right? But let's carry on. Judge McGlynn actually takes it to the next level and says, in addition to being in common use, he also pushes it to the next level and says that these firearms are not even dangerous as the term of dangerous and unusual is defined. Because he goes on to say, in his view, that as long as a typical operator of the firearm is able to control the weapon to neutralize discrete and specific targeted aggressors, it's not dangerous. He defines dangerous as something where you're not able to control the arm as you discharge it, which I think is why he's distinguishing between machine guns, which are hard to control for ordinary people, because once you pull that trigger, as you know, the machine gun kind of takes over, and if you're not kind of well trained in it, it's sometimes hard for ordinary people to handle that, and arguably it may be harder to aim, and you might be more likely to indiscriminately shoot people, causing collateral damage. Now, whether you agree with that or not, the good news is, for the purposes of Illinois, that Judge McGlynn said that AR-15s are not dangerous because it's easy to control and you don't have that kind of collateral damage that you might have with other weapons, such as a grenade, an explosive device, or possibly even a machine gun. So it's not a terrible distinction for our purposes at this point dealing with AR bans. Nevertheless, at the first level, he says that, again, AR-15s and semi-automatic rifles are items that would be kept in the home by Americans for ordinary self-defense purposes. And again, self-defense is not even the factor here, because this, as you know, the Supreme Court says that if something's in common use by Americans for any and all lawful purposes, not just self-defense, it's protected. But nevertheless, the reality is Judge McGlynn found that these rifles were kept in the home and these magazines are kept in the home for the purposes of self-defense. So the first standard was satisfied in favor of the Second Amendment. Then Judge McGlynn goes on and addresses the second question posited by the Seventh Circuit. Again, this is a hooey question, a silly question that has no basis in American law, at least at the Supreme Court level. Nevertheless, Judge McGlynn answered it anyway. And that question is as follows: is the challenged weapon, meaning these magazines and semi-automatic rifles, are they exclusively or predominantly useful in military services? And again, even though this is not a proper question to be asking, it's not even relevant, the reality is that Judge McGlynn said, no, they are not exclusively or predominantly useful in military services. And he laser focuses on the fact, and this is quite an interesting metaphor, he says this is absurd, because he said that an M16 and an M4 carbine are totally different than an AR-15, and that AR-15, these semi-automatic rifles, are not deployed as solely as a semi-automatic rifle in any of these armies around the world. They always get at a minimum select fire firearms or machine guns, but mostly it's select fire. And he says, and this is an interesting metaphor or analogy, he says that treating an AR-15 rifle like an M16 is the analogous or the same as treating a Hummer H3 to be the equivalent of a military Humvee, right? I thought that was interesting to say that a Hummer H3, which we see on the streets all around, is the same as a military Humvee. He says they're clearly not the same vehicle, and to equate the two is simply absurd. That would be the same as equating an M16 with an AR-15. One is select fire, one is a full automatic, the other is purely semi-automatic, and he rejected that distinction. And then he goes on to say, with respect to semi-automatic handguns, which are really actually already protected by the Heller, but he still addressed it. He said that, look, semi-automatic handguns also have this dual use, because in a footnote in the Seventh Circuit's decision in Bevis specifically said if an arm has dual purposes or a dual use, meaning it could be useful for the military and it could be useful for the civilian population, it is a protected arm under the right of the people to keep their arms. And basically, Judge McGlynn says, obviously, like a 9mm or 45 1911, these are arms that can certainly be used by you and by me for civilian self-defense, but certainly could also be used by people in the military. Thus, it has a dual use under that footnote of the Seventh Circuit, and thus is protected under the Second Amendment. So both the first question and the second question were resolved in our favor by Judge McGlynn. That gave rise to the third question that was sent down to Judge McGlynn by the Seventh Circuit out of Chicago, and that is the challenged weapon possessed for unlawful purposes? And then basically here he credits the testimony of certain witnesses that said that the vast majority of AR-15 rifles are never used in any kind of illegal activity. They're almost always used for self-defense or for shooting ranges or for sporting purposes. And that is dramatically different than, let's say, handguns. And then there was discussion, as Judge McGlynn points out, that it's interesting that in the Heller case, which dealt with the District of Columbia's ban on handguns, everyone understood that criminals prefer handguns over rifles. That's why in any given year, long guns, rifles contribute to maybe 300 murders a year in all of America, where you have over 10,000 murders or something like that, arise from the use of handguns. And obviously, handguns are protected arms because the Supreme Court said that a ban on handguns in Heller was unconstitutional. So how is it possible that a ban on semi-automatic rifles, modern rifles, is not equally unconstitutional if they're unconstitutional for handguns in Heller, where a lot more people get killed through homicides by handguns than they ever do for rifles? And basically what Judge McGlynn says here is that it's exactly the case that these rifles are rarely used for crimes, and thus they're not in a position where these kinds of weapons that are talked about during this trial are possessed for unlawful purposes. So after Judge McGlynn answered those three questions favorably to the Second Amendment, again, this is not the right test. This is totally a wrong test, but we're going to play along because the Seventh Circuit made Judge McGlynn play along. The good news is Judge McGlynn made the right decisions. He made the right decisions on these 3 points. So he then says, in light of that, the text is now satisfied. These arms are protected arms under the Second Amendment, and the burden shifts to the government to show whether or not there's some sort of historical analogs to justify banning these guns. Again, this methodology is totally wrong, because the Supreme Court has already done the methodology and the historical work for figuring out what is a banned gun when you can ban guns. Nevertheless, the Seventh Circuit said this is what you have to do, and that's what Judge McGlynn did. And so he went on and said, well, let's look at the historical analog laws that the government is proffering to see if the government can show and establish that these guns can be banned. And he goes on to say that based on history, the government has simply not satisfied its burden because there's something like 8 or 9 historical analog laws that the government proffered, and none of them justified a ban on some of the most commonly owned firearms in the United States. In fact, interestingly, 5 of the laws, according to Judge McGlynn, actually dealt with banning revolvers, which are obviously protected arms after the Heller case. But beyond that, I just want to say one additional thing. We've talked a lot about whether or not mass shootings are unprecedented societal or unprecedented technological change. I pointed out repeatedly that's not the case. The easiest way to prove that is in 2007, the year before the Heller decision. We had the Virginia Tech mass shooting where an individual used semi-automatic handguns with magazines that held more than 10 rounds to kill a lot of people at Virginia Tech in 2007. This issue was raised before the United States Supreme Court in the year of our Lord 2008. And nevertheless, the Supreme Court decided the Heller decision in favor of us, that these handguns cannot be banned under the Second Amendment. So obviously something that is unprecedented societal change or unprecedented technological change is something that's never occurred before. This is language that was found in 2022 in the Bruin case. But as we've talked about before, this clearly does not involve mass shootings because mass shootings were not unprecedented as of 2022 when Bruin was decided. In fact, they weren't even unprecedented in 2008 when Heller was decided. In fact, Heller specifically dealt with mass shootings. And again, if it's unprecedented, it means it never occurred before. Obviously, we're in the year of our Lord 2024, and unfortunately, it's fair to say that mass shootings, however you want to define them, are not unprecedented in 2024. They weren't unprecedented in 2022, and they weren't unprecedented in the year of our Lord 2008 when the Heller case was decided. And that's exactly basically what Judge McGlynn said here. Judge McGlynn said that these mass shootings are not unprecedented and thus do not justify loosening up the historical analog rules for the government to satisfy its burden to justify these bans. And in the short, Judge McGlynn found that the Second Amendment plaintiffs had prevailed in virtually all aspects of knocking out this law of Illinois. These gun bans, with very narrow exceptions for 50 caliber sniper rifles, which set that issue aside. They did find that to be dangerous and unusual and could be banned, is basically what Judge McGlynn said. But I think that's still a fight we can win down the road. But that was the one thing he basically upheld in favor of the government, is 50 caliber firearms, 50 caliber rifles that could be used for snipers. He said that he thought that was not satisfactory in terms of winning for the Second Amendment, and therefore ruled in favor of the government on those. But I still think that's something that we can win down the road. All right, folks, hope you learned something here today. I'll put a link to my article in the Georgetown Journal of Law and Public Policy and a link to Judge McGlynn's opinion down below in the description of this video. Make sure you follow me on X at @4boxofdiner. Don't forget to like this video and share it far and wide. We're trying to grow the channel. And make sure you subscribe if you haven't already. We're still trying to get to 200,000 subscribers. We're working hard to get there. And I look forward to seeing you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.